Okay. Thank you. Good evening. This meeting of the Coventry Town Council will now come to order at 7:30 PM. Roll call, Ms. Ludwig,
Here.
Mrs. Shockley,
Here.
Mrs. Lima,
Here.
Mr. LeBlanc,
Here.
Mrs. Dixon here. Please stand for the Pledge of Allegiance. Mrs. Shockley will lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. The emergency evacuation plan, there are 2 exits. You will note with red signs above the doors. Please exit by the back of the room. That will be the quickest way to exit the building. Thank you. Council, may I have a motion to adjourn into executive session for the following? Per Rhode Island General Law 42465A2, discussion pertaining to collective bargaining or litigation, specifically for an update on the legal disposition of town contracts for wind turbine facilities and renewable energy with legal counsel.
I'll make a motion.
Thank you. May I have a second?
Second.
Thank you. Any discussion? Okay, roll call. Ms. Ludwig?
Yes.
Mrs. Shockley?
Yes.
Mrs. Lima?
Yes.
Mr. LeBlanc?
Yes.
Mrs. Dixon? Yes. 5 yeas, no nays. The motion passes. We are now in executive session. Again. Okay.
Wait for Jamie. Oh, and Henry.
No, thank you. How many run? Zoom?
Five.
Yeah, where's my husband? Is he Dixon up there? I can't see him.
Anderson,
So that's
Henry,
yeah, my husband.
Josh Florence, Kent, and Sandy Russell.
Yeah, okay. Good evening, everyone. Thank you for your patience. We're a little delayed coming out of our executive session, so we do apologize for the wait that you did have. We're now back in public session. May I have a motion to adjourn from executive session at, I guess, 8:15?
I'll make a motion.
Thank you. May I have a second?
Second.
Any discussion? Okay, roll call. Ms. Ludwig?
Yes.
Mrs. Shockley?
Yes.
Mrs. Lima?
Yes.
Mr. LeBlanc?
Yes.
Mrs. Dixon? 5 yeas, no nays. The motion passes. May I have a motion to seal the minutes from the executive session?
So moved.
May I have a second?
I'll second.
Thank you. Any discussion? Okay, roll call. Ms. Ludwig?
Yes.
Mrs. Shockley?
Yes.
Mrs. Lima?
Yes.
Mr. LeBlanc?
Yes.
Mrs. Dixon, yes. 5 yeas, no nays. The motion passes. Members of the public, the town council met in executive session to discuss the following per Rhode Island General Law 42465A2. Discussion pertaining to collective bargaining or litigation, specifically for an update on the legal disposition of town contracts for wind turbine facilities and renewable energy with legal counsel. A discussion took place. No votes were taken. We're now on agenda item C2. The meeting was called today for the following reasons: presentation and analysis of the history of the installation of wind generation facilities in the town of Coventry, a discussion of the WED, meaning Wind Energy Development Settlement and its impact, and a discussion of residents' concerns with these facilities. We will have public comment at the end of the meeting, but we also will entertain questions at the end of each section. So as our legal counsel, Mr. McGilvery, makes his presentation at the end of each section in the PowerPoint, feel free to come up to the podium and I will recognize you so you can ask questions as they come up for each section of the presentation. We will also have public comment at the end of the meeting also. So there'll be plenty of opportunity for public comment. People who are on Zoom, all you need to do is raise your hand if you would like to make a comment, and we will recognize you so you can make a comment at any time. A little background information. When I came on the council in November 2018, 10 turbines were up. WED 2, 3, 4, 5, and 3 for WED 6 were approved in 2014 with special use permits. The turbines at the Pachillo Farm off Perry Hill Road were excluded from permitting because they were on town property. They went up in 2012. And as those of you who travel on 102 and 117 and Route 14, we see the turbines on the landscape. The erection of turbines has not been without controversy in Rhode Island, across the nation, and in the world. My first conversation as a council member was with a resident about the turbines. At a meeting, I received a 3-ring binder with history of the turbines in our town. I spoke with other council persons, the interim town manager at that time, Mr. Wazeker, and other residents, and I requested a legal review of the process used to implement these turbines. I was told also that a former town planner had done a process review. Once I received the legal review in June 2019, the planner's report, and a review in November 12, 2019, which addressed a resident complaint about health issues from subsonic sound, I spoke to the interim town manager about having a meeting with residents at the town hall to review these legal documents. Our invitation to residents to meet with us was not accepted. I did have some informal conversations with residents, but was unable to release the report at that time. It was because it was not official. Simultaneously with some of the events above, I worked with residents on revising the wind facilities ordinance and noise ordinance, walked in the area in which turbines are located, and did a few site visits on property on which there were noted problems with flicker and noise. At the time, our former assistant planner, Brian Wagner, Esquire, advised us that any ordinance change would not affect existing installations because ordinances are not retroactive. The town, as you know, was in and out of court many, many times regarding flicker issues for many, many years. At the time, there was a talk of a settlement with Wind Energy Development. I voiced my opinion of particular aspects of the settlement, and I actually did vote with another council person against the settlement in open session. The settlement agreement, however, was voted by majority and was signed. There continued to be visits and emails from a few residents. By a few, I'm talking about 6 residents. 1 from Cars Trail, 1 from Flat River Road, 1 from Perry Hill, and 3 on 102. One property on 102 is 777 feet from the nearest turbine. Another is 990 feet from the nearest turbine. There were, as will be noted, outside the notification area, which by ordinance at the time was 200 feet notification for abutters. That notification distance has now been changed in a future ordinance, but it's now 2,000 feet. But at the time the turbines went up, the notification was for 200 feet, which I'm sure we all will agree is a ridiculously low number, but that was in the ordinance at the time. I approached our new manager and asked for another review. He selected Mr. Stephen McGilvery, a partner with Atwood Pierce, Providence office. Our legal counsel, Nick Gorham, had a conflict and he was excused from working with the town on the issue. I have been told by a resident that Mr. McGilvery was a town lawyer and is biased toward the town. His background does not suggest that, but yes, the town did hire him for his expertise, so you can say that he is a town lawyer. I went on the website to look up a little bit of the background on Mr. McGilvery, and I'll share that with you. He has more than 20 years of experience advising companies, high net worth individuals, and organizations of all sizes in matters relating to complex litigation, as well as real property disputes, including zoning and land use, title, easement, and access, condominium disputes, adverse possession and prescriptive rights, commercial leases, and claims based on trespass, nuisance, and other property-related torts. He has successfully assisted developers in the appeal of denials of zoning, wetlands, or environmental permitting, and he has also represented municipalities on issues such as ordinances related to renewable energy projects. Mr. McGilvery completed his second report in 2021. And then there was a discussion as to what to do with the report. We talked to legal counsel and with the town manager, and we decided that a public meeting in which all information was put on the table was extremely important. This will be a difficult discussion. We know that it will be, and it's very frustrating for us, and I'm sure for all the residents who have been impacted in some way by the turbines. Now, to begin this presentation by Mr. McGilvery, I expect that people will be respectful to all members of the town and council who are present. If that is not the behavior we will observe, I or any member of the council may request that that person be removed from the meeting. We expect everyone to be very respectful concerning what Mr. McGilvery is going to present. As the presentation is being made, you may appear at the podium or raise your hand on chat, and we'll answer every single one of your questions per section of the PowerPoint. We will also have public comment at the end of the meeting, and council members may also ask questions, but the focus is always going to be on the residents first. Mr. McGilvery, the PowerPoint presentation will also be shared on the screen. If you are not able, where you're sitting, if you're not able to see the presentation, please feel free to change your seat.
Can we not also put it on this TV too, or no? Oh, okay.
Are you all able to see the presentation? Okay, excellent. Mr. McGilvery.
Thank you very much. My name is Steve McGilvery. Some of your faces are very familiar from the various meetings we had over the solar array and the solar statute, which was changed fairly recently. I was hired by the town in 2018 on an interim basis to fill in for the regular town solicitor with respect to energy issues and renewable energy issues primarily. I was not here during the permitting of the turbines, nor during the time when the statute was, or the ordinances were amended to address wind turbines. I was, however, as I just mentioned, here and working for the town during the redrafting of the solar ordinance and quite frankly, the long battle with green energy over the solar installation. At this point, I've never, and at this point, do not have any relationship with WED or Green Energy. They're not a client of my firm, and they're not my client. As I said, I work for the town intermittently. And I should add to what Councilwoman Dixon said with respect to my biography. I've represented municipalities, I've represented developers. I've also represented a number of citizens groups in fighting development. Most recently in Bristol, fought for citizens group, the development of a large condominium project right in downtown Bristol that the citizens thought was inappropriate for the area, and we were successful in that. So I just wanted to, I've been on all sides of these issues. Recently, I was called by the town manager and asked to, excuse me?
Slide, just have him.
I'm sorry. Yes.
Go back one slide.
Actually,
Cody, go
if you go back one slide, I'm
Go
sorry.
back one slide.
So I'll be addressing three topics tonight. The permitting, in particular, was it valid? Secondly, the settlement agreement, the history and how that came about, because although it dealt primarily with the solar installation that WED was putting in or attempting to put in, it did touch upon this wind turbines as well. And finally, we'll talk about what is the path forward and what remedies are available either to the town or to individual citizens. Some of you may be very familiar with what I'm going to tell you. I tried to take as best I could a very hard look at it and give you really a unvarnished opinion as to what the legal setting is at this point. So next slide. What we have here, and hopefully most of you can see that the print is a little small. This is a list of the turbines in the town, the property owners, and turbine owners. In my understanding, Councilwoman Dixon, this will be available on the website.
Yes, we're going to have this presentation available on the website.
So for those
Just
of
to
you,
let you know, it will be available.
those of you who don't have photographic memories, you can go on the website and you'll be able to find all of this information. Next slide. So we started to delve into how these turbines were permitted by the then zoning board. And we determined what standards applied. At the time, wind turbines were permitted by way of special use permit. And a special use because they're not subdivisions of land, they don't need to go through the planning board, at least at the time. All they required was a special use permit from the zoning board. Next slide, please. So a special use, as some of you may know, is a use that's already deemed almost permitted by the town, but the applicant must make certain showing in order to attain the special use permit. The zoning board has to do certain things. The most important of which is to hold a public meeting. And a public meeting is a very specific type of meeting, which requires notice to abutters. Next slide. Some of the things that the zoning board requires evidence of are screening and buffering, general compatibility with lots in the same or abutting zoning districts, compliance with industrial performance standards, which are set forth in Article 7. And the two, I think, which are the most important are compatibility with the Coventry Comprehensive Plan, and they need to show that it's not going to hurt in any way the public health, safety, or welfare of the residents.
Excuse me.
Just to ask, at the time, it seems the zoning board decided that all these criteria were met.
Yep. And I'll get to that. I have a slide on their findings. And there are other findings that the zoning board has to make in order to grant a special use permit, but those are the key ones. And on those issues, the applicant must come in, and the applicant has the burden of proof to show that all of those things, all those standards can be met. Citizens also, particularly those within 200 feet, are given notice, but really in Coventry, almost anybody can come in and try to present evidence that those things can't be met. For instance, that a wind turbine is not, that a wind turbine actually hurts public health, or that a wind turbine is not in compliance or compatible with the comprehensive plan. Those are things that both the applicant and citizens that come to the zoning board present their own testimony, present any other evidence they have, and perhaps most importantly, when it comes to issues like that, present experts. And on that evidence, the zoning board makes a decision. So zoning boards, if they do grant the special use permit, they can do it and set special conditions in order to promote the intent and purposes of the Coventry Comprehensive Plan. So they can say, yes, this is a granted, or this we will grant this special use permit, but only on the condition that you do X, Y, and Z. So the zoning board at the time had that that power, and as it turns out, in the case of several of these wind turbines, they tried to exercise it in certain ways. So we look back and found that the zoning board did hold the required public hearings, and they made the required findings as per Article 4, Section 432 for the wind turbines, and issued the special use permits. Now we've actually gone back to look and make sure that everybody who is within 200 feet received notice. We have the green cards that show that each of the people within 200 feet did receive notice prior to the meeting, and appropriate notice. So and that's a key element, obviously, that people receive notice. Do you want to take questions now? Or do you want to wait?
Please step forward, Ms. Ferry. Give your name and address. Come up to
Let
the,
me interrupt the presentation.
That's okay.
But when you say 200 feet.
if you have a question, please step up here, your name and address, please, and ask your question.
Linda Ferry, Flat River Road in Green. When you say 200 feet, are you saying 200 feet from the bottom of the turbine or from the property line?
It's the property line.
Okay, and you said abutters had to be notified.
Yes.
Okay, but Mr. Sullivan wasn't, who has 5 of them behind his home. He received no notification whatsoever.
I think you're right in that.
And how can that be for something that's 450 feet tall when I can't even put up a fence that is higher than 7 feet? but you can put up something that's 450 feet tall, and only people within 200 feet got to be notified. So
At the time, the ordinance was 200 feet, and Mr. Sullivan's property,
what ordinance?
ordinance 002-18320 code, before May 14th, 2018, we required notification to 200 feet,
Is that a turbine ordinance?
It's a special use.
special
ordinance.
use permit notice.
Okay, and nothing was taken into consideration that these things were 450 feet tall?
So,
No, I'll let you go ahead.
I mean, I can kind of, I wasn't there for these things, but, obviously that's the question that kind of occurred to almost everybody who looks at this. How could something so major that has such an impact on the town be granted after one meeting before the zoning board with only people given the only people given notice are within 200 feet?
Right, 450 feet is going to affect a lot more people within 200 feet.
Yeah, it seems intuitively, or just a matter of fairness, that you would have several meetings over the course of perhaps weeks.
Right. Well,
And it would go before the planning board and be treated more like a major subdivision than, as you said, a fence.
right. I have property that is one piece of property between mine and a turbine.
Right.
So there's the turbines on one property, then there's one other piece of property, and then there's my property.
Yeah.
It is not where I live. It's property I bought 35 years ago for my children to be able to build a home, or my husband and I to build a retirement home. It's a beautiful spot, very high. Now, and you could hear the nature. Now you go up and I look at two turbines,
Right.
and I hear the whoosh. Okay, I'm going to have more questions, but I just wanted, you
Good.
were on that, so I needed to intercept that.
No, I think that's a very valid question. It goes to this kind of this centrality of what's at issue here. What was the ordinance at the time? Did they meet the ordinance at the time? And why was it such a, the harder answer or harder question to answer is, why was the ordinance like that at the time?
Right, and I've seen that list of people that were notified.
Yeah.
But Sean was not.
Yeah.
He's in a butter, and
He,
six of
he,
them.
the nearest turbine was 777 feet from his property line.
So it's
And there's another
He's in a butter.
777 feet. So
Right, but you
he
get to
did,
the property, that's
yes,
absurd.
he didn't receive notification because it was beyond 200 feet. And well, that was the ordinance. There is another member of the audience here today who's within 990 feet
Yep, PJ.
of the nearest turbine. And she was not notified either because it was beyond the 200 feet. Yes, we all agree that 200 feet as the ordinance did not make a lot of sense, but that was what we were dealing with, or people were dealing with at that particular time.
Okay, I'll let
Thank you.
continue then.
Sure. So, and the next slide is going to be almost impossible for you to read, except for those and perhaps in the front row. But these are, and this is probably where you'll want to go to the website later. This is a summary of the special use findings, the decision date, the location, and the owner and applicant of each of the wind turbines, when they were approved, and also what special conditions were applied to each. And in most cases, or I should say in all cases, they met all of the, I shouldn't say they met, but the zoning board made a finding as to each of the requirements, except for signs and lighting, which they felt, I suppose, that didn't apply because it doesn't really require signage like a commercial establishment or most commercial establishments would. Next slide. So the people within 200 feet were given notice. Few appeared. At the end of the day, these things were given their special use permit, which was required. And so from our review, the permitting process that was required at the time, and you all may disagree, and we sitting up here may disagree in terms of how in depth that process should have gone, but the process that was in place at the time was met.
Mr. McGilvery, I'd just like to just mention a little bit about the notification process.
Sure.
As I mentioned before, the ordinance 02-18320 before May 14th, 2018 required notification to 200 feet, which we all agree is a very small distance, but that was the ordinance at the time. The ordinance did not change until May 14th, 2018. Notifications for WED 3 and 4 were heard by the zoning board March 5th, 2014. It was decided April 1st, 2014. Notification was sent out January 15th, 2014 for the hearing on February 5th. So we have all this documentation. Notified for those particular turbines were the Green Company, also the address 710 Perry Hill Road, Flat River Road 5555 and 5580, and also DEM was also notified. Also notified was 394 Cars Trail. The following addresses on Flat River Road, 5605, 5641, 5491, 5483, 5461, 5385, 5555, 5540, and 22 Nooseneck Hill Road. So we do have records for the notification. We do have the signed receipts that the people at those particular addresses did sign. So we do know who was notified, what addresses, and we do have the record of the receipts, just to let you know. That's fine. But the public may not be aware of this data, so we want to make sure that people are aware of it. Come forward, please.
Is it appropriate for me to address the board? I am not a resident, as you are aware. I'm the state representative for.
We understand. Please state your
Okay, thank
question.
you. Michael Chippendale, Foster, Rhode Island, again, state representative for the town of Foster. Just a point of clarity on the setback. The 200 feet, you referenced that there were 900 feet or whatever it was from the turbine itself. Is the setback requirement or the notification requirement 200 feet from the property line upon which that turbine resides, or is it from the turbine itself?
It's from the It's from the turbine itself. It's what.
And that's specifically articulated in the
I don't know if
ordinances?
that's specifically articulated, but that's my understanding.
Is that common practice throughout the state?
That I don't know. Is it?
I do not know.
Oh, okay. So that's, I mean, my, and this is what I said before. I thought it was from the property line, quite frankly.
It is in my town.
Right. So I don't know whether that's something I can look into and try to,
Okay.
we'll take a look back into that, whether these people within 200 feet of the property line, they're one of the, we'll take a look at.
Thank you very much. Thank you, Madam President.
Thank you for the question.
Sorry, I should make this comment publicly, but my curiosity when you look into that would be as to whether that was maybe a legal interpretation made at the time by the town, in which case you as a outside attorney really can't opine on the solicitor's opinion at that time. I really appreciate what Representative Chippendale has said, because it's a very good question. And I would think that normally in all the other communities I've served in, it would be from the property line as well. So it does seem unusual that the town may have followed a different approach.
We'll have to look into that. That's something that
We should look at what we've done in the past as well in other properties and other special use permits to make sure it's following.
That's not a difficult question, but it is something that I was assuming these properties were outside 200 feet from the property line when Ms. Dixon started talking about 200 feet from the turbine. There's some conflict there, so we'll look at that. And
I'm not saying no. I mean, we're all outside, so we're talking 200 feet. Most of us have big yards.
no, that's understandable. There are big properties out there. So let me check that, because that is, again, it's a central issue. And that's something that probably should have been ironed out ahead of time, but we'll nail it down.
Can I ask another question just based on the height of the turbines, which makes a lot of sense as a question? And I don't know if President Dixon might know, does Coventry have any ordinances on building heights? Like you can't build a building taller than?
There is a wind ordinance wind facilities ordinance that does talk about heights, et cetera. I can pull out the number of it someplace. We can look up the distance.
Well, because I would be curious if the wind turbine would fall under a height ordinance for buildings in Coventry.
That's a good question. We can figure that one out as well.
It's Article 20, Special Regulations, Wind Energy Facilities, and we can look through it.
I guess the question is whether that ordinance was in place at the time that these were permitted, or was that a subsequent ordinance with respect to height?
Mhm.
So the height issue is a good one. We'll look at that as well. Okay, so next slide. So the next question is, can the zoning board decision be appealed? And according to both the Town of Coventry ordinances and the State's Enabling Act that covers zoning boards, aggrieved parties have within 20 days of the decision, it's recording and posting to file an appeal. We could find no record of an appeal, and we don't know of anybody who's come forward and said they filed an appeal. So next slide.
Please step forward to the microphone.
Don't apologize. The meeting is for discussion.
Yeah.
About the appeal.
Yeah.
How about, repaying to what you just said, how about the meeting on the zoning board meeting, February 6, 2019, zoning board of appeals, where the zoning board chairman, Mr. Crowe, stated that in his opinion, the turbines are running illegally, quote, all 10 turbines should be shut down, quote, we had been lied to, quote,
we've been duped. All SUPs should be thrown out and start over again. And at that point, I'm quoting him at this particular meeting. And at that point, WED's attorney said, well, then we will, didn't say answer that, but we will oppose that. But that's what the chairman of the zoning board said. In his opinion, the turbines are running illegally. All 10 should be shut down. We have been lied to. We've been duped. All SUPs should be thrown out and the process started over again. Mr. Crowe stated that on 2/6/2019. Also around the same time, at a planning board meeting, Mr. Flynn stated he had reviewed some of the videos that Mr. Sullivan had been told to meticulously record at the town hall. I don't know if any of you have seen any. There's a lot of them there, whether they just appeared or not since Brian left, I don't know, but he was ordered by Carolyn at the time, Carolyn Wells, and Brian had ordered him to keep track of everything, so they were there. Anyway, Ron Flynn, who was acting as chairman of the planning board at that time, stated, I'll tell you what, I looked at those things and I would not want one of those behind my house. So I'm just stating that what Mr. Crowe said, what Mr. Flynn said, and what Mr. Crowe said about his opinion. He's the zoning board chairman, and this is at a zoning board of appeals meeting.
Yep.
That, in his opinion, they were running illegally, should be shut down, and the zoning and the SUPs should be thrown out.
Yep. So to that, I would say I think there's a lot of people who are sympathetic with that position. And they voiced that position at numerous times, either this body or zoning board and planning board. But the legal question that I looked at was a separate one, which is when you can file an appeal. And the ordinance is very clear that it's 20 days from the recording or posting of the decision on the special use permit. So whatever, usually a week or so after there's a verbal decision during the meeting, and the written decision is recorded and posted, and that starts the 20-day period, and someone has to file an appeal within those 20 days.
what if the developer,
Please come forward.
What if the developer is consistently violating the terms of the SUP?
Yeah, well, that's a separate issue, and we'll get to that a little
Okay.
bit later. So there were likely also, although I haven't looked at them and laid hands on them personally, building permits issued for these turbines. And again, there's a time limit for filing those appealing those building permits, and there's no record of an appeal. So what does that mean legally? Next slide. There's a principle called administrative finality. It's kind of twofold. It's a waive it or raise it or waive it during the hearing, but it's also a rule that if you don't bring an appeal, you can't subsequently attack the process for being improperly conducted. So again, this is a well-known Supreme Court case. If an appeal is not filed, the decision of the administrative body is not subject to attack based on its incorrectness or purported failure to follow the proper process.
Whose responsibility would it be to?
Please come up forward. Please come forward.
So whose responsibility would it be to file the appeal?
Yeah. That's a good question. So appeals can be filed by aggrieved parties there who have standing. Aggrieved parties are people who are within the notice.
Okay, so the residents are aggrieved.
People who are within the notice area. So in this case, 200 feet. There's also some case law that says that aggrieved parties may be outside that 200 feet
Right.
if they experience negative effects to their property, diminution of property value, other harmful effects.
Okay, so we know that that has happened.
Right. So there are probably a number of aggrieved parties, none of whom brought an appeal.
So should not the town be appealing on their behalf?
No, the town, a body of the town made the decision. So an
Right.
arm of the
So
town.
wouldn't
made
it be like in Falmouth, when they brought theirs down, their town council had to sue their zoning board? They had to sue their own zoning board
Yeah.
to get their turbines.
I have not seen that done in Rhode Island. I don't have knowledge of any case law where the town council has sued their own zoning board. What the rule in Rhode Island is that only aggrieved parties can bring appeals. They're the only that have a standing. And if they fail to do so, and they've been given notice, which is why the notice question you asked earlier
That
is so important.
small amount of, those small little group of people that were given notice.
Yeah, no, that's why this, they're like building blocks, one on top of each other. It's that small group, but also other aggrieved parties. So people who may experience flicker in the future, if they knew it at the time, which is really kind of the problem. Before any turbines went up, no one, I think, really understood what impact they would have. And so they went through a very abbreviated special use process. Nevertheless, once that decision is posted, you need to have a aggrieved party file an appeal, or it becomes final.
And how, nobody knew.
Well, the people who were there.
Extended agreed people had no idea till they were driving down the road and these things are up.
Right. No, I mean, that's the issue. They give notice at 200 feet of butters, and then they give notice in the newspaper. And if you're not paying attention and it's just a special use permit,
Well, too bad.
it's kind of a well too bad. No, I'm not trying to, I'm obviously not trying to sugarcoat it, but I'm trying to tell you just what my understanding of the law is on these issues.
Thank you. Mr. Shockley,
And
question.
Ms. Ferry, if you could stay, my question is actually for you. So do you know in the town of Falmouth if the zoning board had not followed town ordinances? A lot of the research we're doing it's to find out, is there anything that was done wrong in the process? I think we're coming away tonight with a couple of questions, but from what the findings are till now, the process wasn't done incorrectly, even if we don't agree with the process. So I'm wondering if in Falmouth, if the zoning board had actually not done the
No,
process correctly.
The issue was not the process. The issue was the harm
Okay, so
that
they
was being
decided that
done
even though
to
everything was
residents
done right.
beyond 200 feet.
Okay.
So that, and Mr. Ambrose, whose information was in that packet I gave you, Mr. Ambrose and his colleague testified in Falmouth, and they had a big impact on Falmouth's decision to admit that the town had to admit that they made a mistake, and agreed that the turbines were causing harm and taking them down. So it wasn't the process; it was the idea that they were doing harm.
And was it after the turbines were already up that
Oh,
they
yeah.
were able to take them back down?
Yeah.
Just wanted to make sure this group
Were the
understood.
turbines on town property?
Excuse me?
Were those turbines on town property?
I think, not sure. I think they were. I think they were.
Thank you. Mr. LeBlanc, you have a question?
I do. Mr. Gilroy, when it comes to the fact that residents only had 20 days to file an appeal, were the turbines up in 20 days?
Most likely not. I obviously don't have that information, but I would find it hard to believe that they went up within.
So as an attorney,
Yeah.
wouldn't you say that there wasn't due process for the abutters that now know once the turbines are up that they are impacted and they only had 20 days to file an appeal?
Well, no, as a matter of due process, the notice and then the applicant comes, they describe the project. The zoning board is supposed to ask, difficult questions. There's supposed to be a showing that it's in compliance with the comprehensive plan, that it doesn't hurt health and welfare. All those things are supposed to be addressed at the meeting. Could you have a appeal process that first waited till the project went up so you could see its impacts before you appealed? Be highly impractical. And the reason is no one would build a building or a house or any other type of structure if they knew that someone could appeal and then you have to take it back down. So that's why you have administrative finality. You have a chance to make your case, both the applicant and the citizens. You have a time for an appeal. And then there is a societal and governmental interest in finality at some point so that people can take that decision and act upon it.
Thank you.
Any other questions from members of the council?
Yes.
Mrs. Lima.
And just to clarify, even if we wanted to change that 20-day window and make it longer as a town, we couldn't do that?
That's my understanding. And the reason for that is that the Zoning Enabling Act, which is passed by the legislature, state legislature, and that sets the broad parameters within which cities and towns can make their own ordinances affecting zoning and planning. The exact section is 452469 is the section of the State Enabling Act, which requires 20 days.
Do we know if that's the standard across other states, 20 days?
Other states, I don't know. All cities and towns in Rhode Island, 20 days.
They have to follow because of the state. Okay.
Thanks. Mr. Houghton, are there any hands up in the, for the people who are on Zoom? Okay, just alert me because I can't see the list. Okay, thank you. Mr. McGilvery?
So that's the first section on the permitting. If there are any other questions or discussions, raise them now. I'm going to go into the settlement agreement, which was something I was involved with. I was involved because it stemmed from the WED's attempts to permit a large solar installation in Coventry. So can you go to the next slide? I'm sorry. And then the one after that. So as some of you who are involved with that know, that was a very contentious issue before the planning board. The planning board actually denied WD or one of the, I forget exactly what entity it is, but it was one of the WED green development entities controlled by Mark DiPasquale. They actually declined to grant master plan approval to erect the 5.22 megawatt solar farm. And that was appealed by the applicant, and the zoning board denied their appeal. It then went to Superior Court, and the judge in Superior Court also denied or sustained the zoning board in their denial of the appeal. It actually then went to the Rhode Island Supreme Court on writ of certiorari, and the Supreme Court denied cert. The next one was a solar enforcement action. This was WED and Green Development. Despite being denied master plan approval, we woke up one Monday morning and they had begun to install the solar field irrespective of that. So we went in, ran into court early one day, and eventually the judge encouraged them and they agreed to stop before a TRO was issued. And we eventually had to file a separate enforcement action to prevent them from installing the solar field. The flicker appeal was as I indicated earlier, when the special use permits were granted, there was a special condition placed on those special use permits that allowed for 30 or limited, should I say, 30 hours of flicker to be basically endured or placed upon a residence. And there are two sentences in those special use permits that create an ambiguity. To me, it's pretty clear that what was meant that it was 30 hours total from all of the wind turbines that were being erected, not 30 hours a year from each turbine, which was the position the applicant was taking. So the assistant planner at the time issued notices of violation, imposed a $200 a day sanction for each day Sean Sullivan's home had excessive flicker, and a one-time fine of $500. The applicant appealed that to the zoning board. The zoning board denied the appeal, and we went to Superior Court, and it was pending before Superior Court at the time the settlement agreement was reached. The town also had the flip side of this same issue. The town had to, in order to have the NOVs enforced, in order to have the flicker reduced while the other actions were pending, the town had to file its own action to enforce kind of the injunctive or equitable part of the NOV. Mainly, we asked the judge, hey, make them stop exerting excessive flicker while this is being litigated. And as I note here, the existence of excessive flicker was a difficult issue because first, this ambiguity allowed them to argue that they had 30 hours per turbine, but also just measuring the amount of flicker. Flicker is measured from, it has to be inside the home. So it's not just a flicker on a roof, it has to go through a window. And Sean Sullivan the property owner in question had put a significant amount of time and effort into documenting how much flicker there was. But the applicant, or I should say WED, they weren't the applicant at that time, had their own experts saying that there wasn't 30 hours of flicker. So it was going to be an evidentiary dispute before the Superior Court. There was another action that was pending, which was the same entities on the Capwell property were storing containers illegally. The assistant town planner noticed this and issued NOVs. After a period of time, began to impose a fine. They appealed that to the zoning board. Zoning board denied their appeal. The appeal went to the Superior Court and was sitting in the Superior Court at the time of the settlement. Not that all of those lawsuits weren't enough. Late in the game, WED filed an abusive process action. Are you following me on the slides? I'm sorry, I can't see.
Cody,
Okay.
it's on.
Where the WED entities claimed that there were damages in excess of $85 million. The assistant town planner and the finance director were individually liable along with the town, according to the plaintiff. The town, in return, filed a counterclaim for abuse of process against Steve Pasquale personally and against the WD entities involved. Those were the lawsuits that were pending at the time. They were being successfully defended. The $85 million suit, the town was not particularly worried about in terms of eventual damages, but these suits were beginning to accrue substantial costs, attorney's fees primarily, just because there were so many briefs, so many appearances, so many things that had to be done to fight this kind of onslaught of cases against the town, but also cases that the town had to bring itself in order to enforce its own ordinances. So with legal fees mounting, the judge, a judge suggested, and both the parties eventually agreed to go to mediation. The town had been fairly adamant that it wasn't going to settle. They went to mediation. I was at that mediation, and basically, I think the best way to put it is WD and Green Development started offering such large dollar amounts that the representatives of the town at some point felt it was the town's interest as a whole financially to settle the suits. And this settlement agreement, as Ms. Dixon indicated earlier, was approved by a majority of the town council. And I should say at that point, or at this point, the members of the town council have a fiduciary duty to the entirety of the town. They have to do in their own judgment what is good for all of the town, not just particular interest groups or particular groups of citizens. So whether you agree with it or not, I think the reasoning of those who voted for this settlement was that it was better for the town as a whole to cease the litigation and the litigation costs, and at the same time receive significant funds in return. And I'll go over just what were seen at the time as the benefits to the town. There was an immediate payment of $146,000, which was non-refundable. So even if the town did not eventually allow the solar field, and we're talking only about, again, this settlement agreement stems primarily from the denial of master plan approval for the solar field. So there was a $146,000 payment to town, which was non-refundable. Eventually, $800,000 total paid to the town, provided that the solar field was approved through an administrative process that involved the town planner making sure that it met all of the requirements, all of the checklists, but it did not include further proceedings before the planning board. It involved the release of liability to the town and individual defendants, the dismissal of all lawsuits. It involved, there were 3 parcels in question, which gave the applicant significant ability to develop the property. I forget exactly how many acres were involved, but it could have been developed even in a 5-acre zoning. It could have supported a significant number of homes. So as part of this agreement, there was a written conservation put in place on all 3 parcels. The 3 parcels were merged. That easement runs to the benefit of the town. And there's an open space site plan filed in the land evidence records. Excuse me. That open space easement had certain out zones, one for the solar field, another one for 2 homes, and I think there was a provision for 3 barn structures. The Visual buffers were to be put in place. I'm sorry.
Thank you. On that note, Mr. McGilvery,
Pull the
Why-
microphone down a little bit, Linda.
why was and correct me if I got something wrong, but why was the solar array in District 2, what I read was it was denied because it wasn't compatible to their comprehensive plan. But this, and there are R3, but this one that was allowed to Mr. DePasquale was allowed, and it certainly isn't compatible to our comprehensive plan. We're RR5.
Yep.
So what's up with that?
Yeah, it's a very good question. In fact, I think if I remember correctly, but I have to go back and look at the record, I think the master plan approval was denied because the planning board didn't feel it met with the comprehensive plan. And that was one of the arguments that one of the issues that went all the way to the Supreme Court was if it meets all the dimensional setbacks and it's otherwise permitted by the town as a permitted use, does it by definition meet the comprehensive plan, because the comprehensive plan and the zoning ordinances are supposed to work kind of together, and the zoning ordinances are supposed to be designed so that they implement the comprehensive plan. Does that make sense? That was.
I'm sorry, can you explain that a little bit? How come-
It's a little bit of a complicated legal issue, but
Yeah, so how come the solar array in District 2 doesn't meet their comprehensive plan? So it got denied, but the one in our district didn't get denied, but it still doesn't meet our comprehensive plan. And Ian, you admitted the one on Lewis Farm Road is, they said they were going to put all kinds of buffers around it and everything, and it's an ugly eyesore, the one on Lewis Farm Road.
Yep.
So I just don't understand that.
yeah, well, and this is what is interesting about these settlements of lawsuits is that.
But
the
it
town-
either meets comp plan or it doesn't.
I agree. And the planning board felt that it didn't meet the comp plan.
Didn't.
And that's why it denied. Yeah, that's my understanding or recollection, I
So
should
then
say.
why was the settlement agreed to?
That was a political decision that the
Got it.
town council
Got it. It
made.
was a 3-2 vote. Got
Yeah,
it.
it was a 3-2 vote. And all I can say, and I'm not saying that either side was correct. I think they each had their points. The people who voted for it, I think, thought that the value to the town as in its entirety was worth a solar field that couldn't be seen from the road, is the way they described it.
Okay, thank you.
Yeah, but you're right. It was found by the body that makes that determination, the planning board. It was found not to meet the comprehensive plan. If my recollection is correct, I'm pretty sure about that.
And we're RR5.
That's correct.
And I think the important distinction was that the solar array did go before the planning board, but the wind turbines did not, because the wind turbines were a special use by the zoning board, which was a different body that looked at different considerations.
Right.
I understand that.
The solar fields at that time received quite a bit more scrutiny than the
but
turbines
either
did
way-
back in 2014.
Right, either way, the state of Rhode Island determines solar and wind as manufacturing, industrial manufacturing, and it doesn't meet the comp plan. It doesn't meet our comp plan for non-industrial rural residential area.
I forget exactly the rationale where they said it didn't meet the comp plan, whether it was because of some definition like that or just in general. I think they thought the use was too intensive, if I recall.
Yeah.
And that the intensity of the use was out of place with the area.
Right, we've got 10 of them in a rural area.
Well,
We become an
again,
industrial zone.
we're talking about the solar field in this
Okay, good.
instance. They felt that the reason why they didn't grant master plan approval was because the use was too intensive for the area and therefore not in conformance with the comprehensive
Okay,
plan.
so why is that not true in our district?
Oh, this is the one I'm talking about in R5. This is the one that was subject of all the lawsuits.
Okay,
The planning board said it wasn't in compliance. The town council voted to settle the litigation irrespective of that.
okay, and that's where you said it was kind of a political decision.
It was it's a political decision to settle the lawsuits.
Thank you. Thank you.
So back now to the settlement agreement. It required visual buffers for this solar array, but it also tried to address some of the ambiguity in the special use permits for the wind turbines. The applicant or Green Energy had to agree that the 30-hour special use limitation or condition was aggregate as and applied to all turbines, so that combined they would only have 30 hours. There was also an effort to make it self-enforcing, and that was to there were monitors that were placed on the wind turbines, and they were to be monitored by Epsilon Associates, which was the town's independent engineering firm. And that was supposed to happen in perpetuity to make sure that these turbines were not exerting more than 30 hours in the aggregate onto any individual dwelling. My understanding is that that has been monitored. I don't know if Epsilon Associates has been involved, but that has been monitored by the town. But anyway, next page. The settlement agreement also, this is where the settlement allowed the solar installation to be approved by administrative process. Although the standards were applied by the town planner instead of going back to the planning board or the planning commission in this town in the zoning board. There was a tax stabilization agreement whereby turbines were taxed at $5 per kilowatt hour of capacity for 20 years, which reflects the maximum rate allowed by state law. Next page. So in the end, as I said, by a 3-2 vote, the town council believed that the agreement was in the best interest of the residents generally and to the town generally. And as I indicated, that's where their fiduciary duty lies. So I'm done with that section.
Any other questions people would like to ask? Please come forward if you'd like to ask a question. Please state your name and address, please.
Good evening, Madam President and Council. My question is...
Your name, please.
I'm sorry, Anthony Marshall.
Anthony
Flat River
Marshall.
Road and Green. I'm going back to the settlement and the array. When the arrays were started to be put up, he was done illegally without any approval.
Yep.
When he was driving the stakes in for the panels, my house rocked, shaked unbearably.
Yep.
I emailed yourself, Ms. Dixon, and I got to the point where I told my wife I was working. I said, call the police department. She did. They went down. He had a cease and desist order on him, I believe. Mm-hmm. His answer to them was, we're done for the day. That was the answers that we were getting. Okay. Now, this settlement of $802,000 is going to the town. Why isn't it distributed to the residents that have to deal with this? We get nothing from it. That's my question.
Yeah. Well, let me address, I think the three issues that you just raised. One was the illegal installation, and it was an illegal installation. And
Yes, it was.
That's what we were dealing with, an entity and an individual who, despite not receiving permission from the town, went out and did it anyway.
Correct.
And I got a call early. It was, I believe, a Monday morning, and went straight, instead of going to work, we went straight to see Judge Leach in Kent County Superior Court to get it stopped. But that gives you some indication of kind of what everybody's been dealing with, but with the town in particular. So the second thing is, it was actually an $800,000 total settlement, not 120. 146 of it was non-refundable, was the only other point that I made. Why isn't it going it does go to the citizens generally, by going to the town, it goes into whatever fund that the town council deems is appropriate. Again, it's for the town council to make decisions as to the appropriation of funds. Their duty, again, lies to the town as a whole, not to individuals when they're making financial decisions. Rhode Island Supreme Court case law is pretty clear on that. But ultimately, that's not a legal determination for me to make where that money goes. All I can do is tell the town what their duties are.
Mr. McGillivray, I think that's actually something that we want to continue a discussion on.
Okay.
So we haven't made a determination as a council as what to do with that money just yet. So I don't want to say we're going to determine that in this moment, but we're certainly open to some of those ideas.
Okay. Thank you.
So this is why we specifically asked Mr. McGilvery to address the issue of what might the WID funds be actually used for, because we know that there have been questions from residents, especially some people who are here. Mr. McGilvery has advised us, at least this evening, and you heard what he said. In general, money has to be used for the good of the entire community and not for just a targeted group. So we can explore that in more detail, but we haven't touched those funds at all at this point in time.
Unfortunately, the targeted group of people are residents that we've been fighting, but nothing seems to be getting done.
Yep.
And we're all frustrated. To be quite honest with you. Going back to the turbines, I didn't know a turbine was going up until they were bringing the blade in, one of the blades, and it got caught in the tree in the road and it shut the whole road down. Somebody came out with a chainsaw to cut a chain so it could make the turn. That's when I found out that it was raised that day.
Yep.
Nobody else knew about it. But again, that was, these are the questions that I had for you.
Yeah.
Thank you.
Thank you.
I would just add the $800,000 was not related to a settlement of any turbine case, except for the flicker was kind of ancillary.
Yep.
The $800,000 was really related to the solar.
To the solar.
field. So.
And it was also related, I believe, to all of the expenses that we were having in fighting in court.
Well, there was a number of.
And there were a number of violations too, that they owed us money.
It all stemmed, quite frankly, from the fact that the solar field was denied.
He did not care about the violations.
And
he was just going to do what he wanted to do. And that's the message that he sent to the residents.
It was a concerted effort to put pressure on the town.
Mr. Marchand.
Yes, thank you.
There was a question raised about the amount of the ultimate settlement that has been paid to the town. And as the finance director, Ms. Mills, correctly reported, the town received total funds of $765,332.23 of the $802,000 that was agreed upon. And that reflects a number of invoices that were due to WED and legal costs in the amount of $36,667.77. So we did receive the full amount net of expenses that we were due.
Thank you. Okay. Certainly come forward, please.
Janice Tenson,
Your address, please.
670 Nadia Oak Road.
Thank you.
Just a quick question. I'm trying to follow what you're saying. So the initial payment was 146 something thousand, et cetera, of the total 800, et cetera.
Yep.
But several times you kept saying that only the 146 was non-refundable.
Yes.
So is there something else that we should be expecting? Is there going to be something refunded for some reason?
No, so that's a very good question. I'm sorry, I probably didn't describe that as clearly as I should have. The 146 came to the town immediately, irrespective of whether the town planner ultimately approved the solar field. The remaining came to the town upon approval of the solar field. They have been both paid to the town at this point. None are refundable.
Okay.
The parties have fully released each other with respect to these issues, and there's a covenant not to sue. So to the fullest extent that one could draft protection from the town is protected from any type of claim by Green or WED to try to attach those funds or get to those funds in some way.
Okay, thank you.
And I think that's fairly unlikely that they'll try to do that.
BJ Knapp, 2151 Victory Highway.
You can raise the microphone a little bit.
I know,
Be
I'm
more comfortable.
a bit taller than you. You said covenant not to sue.
Yes.
Does that flow both ways? So now the town of Coventry can no longer take legal action against green energy for any future violations?
With respect to the lawsuits that were filed.
So those are closed, but any new violations?
Yes, new violations, and we're going to go over that. New violations, the town can certainly issue new NOVs for any violations of both the ordinances and the special use permits, as now clarified by the settlement agreement.
Okay, thank you.
Sure. That's a good question, though.
Mr. LeBlanc?
Just because you referenced ordinances, can you just clarify for everybody here, if we as a council establish a new ordinance related to turbines and flicker, we say only 10 hours per year, that has nothing to do with the existing turbines. Can you just confirm that?
Yeah, the ordinances don't act retroactively, and they would be grandfathered in under their present use.
Okay, thank you.
Speaking of
Your
ordinances.
name again, please. Sorry.
My name again, BJ Knapp, 2151 Victory Highway.
Thank you.
Speaking of ordinances, noise ordinances have been around since before electricity, basically. How do the noise ordinances relate to the wind turbines? They are quite noisy at night. I often get woken up at approximately 3 a.m. most nights a week.
Yep. I am going to address that. So when I go through that, if you still have a question afterwards, come back up.
I will be patient. Thank you.
Any other questions? Do we want to go to the online audience to see if anybody has?
He's gonna alert us if there are any hands raised.
Okay.
Are there? No, thank you.
Okay. So then the next section is other possible remedies. So we looked into.
Go back one.
Sorry.
Go
Yeah,
back
there
one
you go.
slide. Great, thank
There
you.
you go. We looked in.
Come
Okay.
forward, please.
Hi, how are you? Kelsey Marinelli, 445 Perry Hill Road. So just to speak on the retroactive, I saw a meeting video, April 24th, 2019, Planning Commission, where Brian Wagner stated it could apply retroactively so long as it didn't constitute an extreme burden on the developer.
Yeah, I think Brian's given the opposite of opinion to the town, and that I can look into that. That's not my understanding, but I'll add that to my list of clarification points. Whether it can be retroactive except for an extreme burden. Okay, I'm not familiar with that off the top of my head, but I'll look into it.
Okay, thank you.
Right.
I have, excuse me. I have an email that Mr. Wagner sent to Mr. Wazeker and Mr. Crossman. It says legality questions. While we cannot impose new siting and construction standards on something that has already been built, we can impose reasonable operational requirements as an exercise of the town's police powers. What we cannot do is set operational requirements that would effectively put one or more turbines out of business by preventing the owner from making a reasonable return on his investment. Doing this would arguably amount to a constitutional taking that could potentially require the town to compensate the owner. So that was an opinion that he had rendered. Now, we would have to pass this by our own legal counsel at this particular time, but that was an opinion that he provided, and I had asked the question.
Yeah. So that's I think that's a short way of saying I think your recollection is correct. What he's saying is you can do retroactive, except where it constitutes a taking, which is, almost putting them out of business. So, okay, so other possible remedies, decommission for non-generation. So they have, you can, in certain circumstances, decommission turbines when they stop ceasing the production of electricity. In this case, that's not happening. And in any event, that regulation came into effect after these turbines were permitted. And we also think that just in terms of a court for a sporadic or intermittent production of electricity, would they actually force the turbine to come down? We think that's unlikely. The turbine owner would have several legal defenses, including reliance and the fact that they were permitted, they've been paying taxes for a long period of time. They've got an investment into the turbine, things like that, that from an equitable standpoint, we don't think a court would ever make a turbine owner tear down or bring down the turbine simply because they cease producing power for some period of time. Next slide. So we looked into a nuisance suit. A town, and this is somewhat in line with the earlier discussion about what duties the town has to its citizens. The town can bring an action only to abate a public nuisance, not a private one. Because the noise and flicker, and I'm sure people will disagree about this, but because the noise and flicker are primarily impacting abutting neighbors as opposed to the town as a whole, and it's the abutting neighbors, or not necessarily abutting, but nearby neighbors who are experiencing flicker and have allegations that that these turbines are interfering with the enjoyment of their land. That's a private nuisance. And private nuisance, the individual citizens have standing to bring a claim for private nuisance. And there's a case there, Hawkins v. Town of Foster. In any event, again, even if whether the town or the citizens brought a claim for nuisance, and we think only the private citizens have standing to do it, it's very unlikely that a court would say, take the turbines down. More likely or not, they would make an order trying to abate the nuisance, either noise or flicker. So the likelihood of success in having the turbines removed is almost nil. And in my opinion, the best that possibly could be achieved is perhaps a reduction in the claimed nuisance. But even then, that's a tough case. The owners would say, hey, these are permitted activities. They've been going on for a long time. There are lawful activities. Therefore, they are not a nuisance. It would be a difficult case. Next slide. Of course, the remedy that was touched upon just a moment ago was enforcing the ordinances and the settlement agreement, which attempts to clarify the special use permits. So noncompliance with the special use permits, the zoning officer can, again, issue an NOV. So if there's more than 30 hours aggregate, there's nothing in the settlement agreement. There's nothing that's gone on thus far that prohibits the town from enforcing on an ongoing basis its ordinances. So if there is a violation, that should be reported to the zoning enforcement officer. The settlement agreement is written so that Epsilon Associates is supposed to be an independent engineer monitoring these things. To the extent there's 30 hours a year exerted on a property in the aggregate, that should be reported and an NOV can be issued. And again, that's the second point there, is that the settlement agreement was designed. It was an attempt to resolve the issue of legal proof by having by having Epsilon Associates or some other independent engineer monitor and be the determinant on that issue. Next slide. Other possible remedies, noise. My understanding is that noise from the turbines has really become more central to people's complaints about the nuisance created by the turbines. The existing ordinances do regulate noise in residential districts where the turbines are located. That's the 5-acre zoning. The noise limit is 60 decibels at the property line. So you would need, when it exceeds 65 decibels, you would need someone with a noise meter to record that and report it to the zoning official, who could then issue an NOV. It's 60 decibels for pure tone. And I don't know a lot about the science behind this, but the definition of pure tone is any sound which can be distinctly heard as a single pitch or set of pitches. And that's 60 decibels.
Excuse me, Mr. McGillivray. So let's just use Ms. Knapp's example. It's 3:00 in the morning and we hear, it's a Thursday night, and 3:00 in the morning I wake up because there is loud turbine noise. Could I call the local police department to ask them to come out and listen on my property?
Can you? Yes. Should you? That's what I would do. And I would instruct the police department. I would imagine they have a noise meter.
I do.
And they would come out and stand at your property line and see if it exceeds the ordinance.
I have a question. In the special use permit that was issued June 4th, 2014, it says that among the findings of fact, the project should not exceed industrial performance standards.
Yeah.
Now, are the turbines considered industrial units? Because this is what the special use permit specified, industrial performance standards relating to whatever standards apply, noise, et cetera.
Yep. I would say two things. One, just because they incorporate the industrial standards in doesn't mean by definition they are industrial. That's a separate, are they commercial? Yes, they're commercial. Are they industrial? I believe that's a term of art and used in other places in the ordinance. I don't have an opinion on that. I know that's been an issue for some claiming it's an industrial use and therefore not consistent with the comprehensive plan. Others say no, it's a green energy, passive green energy, and it is industrial, albeit it is commercial. It makes money.
Okay.
So the farms.
Okay, I wanted to ask that question because it appears in many of these special use permits,
Yeah.
the language in it.
So the ordinance could incorporate any other standards in. They could say you have to meet the standards for amusement parks. That doesn't mean it's an amusement park. It's a simple way of incorporating standards that are found somewhere else in the ordinances.
Mhm.
So I don't have an opinion as to sitting here as to whether these are industrial or not, or fit the definition of industry.
Okay, thank you. Mrs. Ferry?
Referring to the question that Jen just asked Mr. McGillivray about in 3:00 in the morning, if you hear a noise, you call the police, and Mr. McGillivray said, yes, do that, correct? Okay, when these first went up 5 years ago, that's what we were told to do. Many people did that. Sean, I know, did it repeatedly. The police came out and said, what do you want us to do? We don't have a meter to measure these things. We can't do anything. We don't have the right meter. And then remember when we had discussed about the type of meter that was needed? Brian had researched that, and Mr. Crossman said that he could get the $4,000 that was needed to purchase the specific type of meter that was needed to measure that noise. Remember? And then that just got dropped.
I spoke to the police chief just on Friday, and I asked him about measuring noise, and I said, what kind of devices do you have? Is there anything better that you can use to measure decibels? Because I was questioning whether the units that they were using were giving accurate measurements or not. So I asked him to pursue to see if there were any other devices. The unit that you're talking about was something that was going to be placed inside a home to measure, I believe, infrasound. So we're talking about two different measuring units. One was measuring sound outside the home, and one was measuring infrasound because there was a suggestion that sound that you basically cannot hear, but might be able to feel mentally or physically in some way, could be measured. And we had looked into the possibility, but it was a couple of years ago that did not
So
actually
can
take
that be
place.
readdressed?
We could readdress it, but there was an agreement that that unit was going to be placed inside the home, and I had expected that in January, maybe it was 2019, that the unit would have been placed inside. But then for some reason, the person who had agreed to have the unit put in his home said he did not want it in his home.
Well, we have other residents that would be willing to do so.
So that was a history of the conversation based on the two measuring units that we had talked about. Yes.
Do you still have the information on the type of equipment that Brian had found? Remember, he had come up with the particular device that was needed?
I do.
I remember it cost $4,000.
I do not have that.
Do not?
But I'm sure that this information could easily be found.
Okay.
Okay, thank you.
Okay, and while we're on noise, I don't know if this is the time or you still have more to.
No, go ahead, please.
No, I'll let you continue. Go ahead. I'll be back.
Okay, we have questions from members of the council, and Mr. Rogers next.
Yeah, I just want to
Mr.
ask
Shockley?
quickly, the police do have some sort of measurement device for sound.
Yes, they can measure. They can measure decibels. They have to when they are called. They have to measure. They have to hear the sound. So I might hear something, and then by the time the policeman gets there, that sound is not great. It's not audible at that point, because I've had that problem myself with excessive noise in my neighborhood. But by the time the police came, the noise had stopped. So there was nothing that could be done.
But if they did come to your home and the noise was still, you could still hear the noise, they have a device that could measure the decibel level.
They can, but what they told me that it's very difficult to go above the limits that are actually in our ordinance.
So it might be something to look at what our limits are. And even though that's not retroactive, once a resident hears something at the limit we set, if we were to change it, that would be a violation.
It might be a violation for some kind of new installation of something or other, but not necessarily that, because I don't know if that ordinance would be retroactive.
So hold on. Now I'm getting confused. We have an ordinance for sound at 65 decibels. We have a police group here that has a tool to measure sound. And we have citizens that are complaining of noise. So what do we need to do? And I'll direct this to Ben, to Town Manager Marchand. What do we need to do to work with Chief Heiss and the police to get some updated measurements?
As I suggested, if there's a complaint about loud noise, to call the police and they will respond and take the measurement. But as President Dixon indicated, they have been going out and measuring, and none of the sounds exceed the 60 decibel limit.
Because
And
they don't have
that's
the
where
right
we're stuck.
equipment. They need that $4,000 piece of equipment. Correct, Ann?
Well, the $4,000 piece of equipment was something that was going to measure infrasound inside a house.
Right.
It was not measuring sound outside your home.
Right, because vibration occurs, not just sound that you can hear with the human ear. There's other sounds that are irritating. That's why you need a better piece of equipment.
Correct.
And on that point, we don't have an ordinance that
Don't have an
addresses
ordinance that addresses
infrasound. So even if we could measure it, it would be fact gathering and data gathering. We don't have an ordinance to issue a notice of violation for that.
But we certainly can pursue.
Yeah,
looking-
remember we had talked about having a noise study done?
Yes, we can certainly pursue looking at what types of devices that might be available. Well, I just told you, I did speak to the chief on Friday and pursue the discussion again.
Okay, and what about the town having a noise ordinance done that we had mentioned before, that we had discussed previously?
The noise ordinance would not be.
I'm sorry, a sound study. I'm sorry, sound study.
Well, the council has not approved nor had a discussion on a sound study, so we would have to take that as an agenda item.
Okay.
Thank you.
And just for my own edification, does anyone know of something that we can compare that is 65 decibels? Like what noise would violate the ordinance?
I can comment on that. So the CDC actually has a list of things that can cause noise, and obviously any decibel that might cause harm. It says a normal conversation is 60 decibels. It says a lawnmower is 90 decibels, and a rock concert is 120 decibels. Just for knowledge, just wanted to share that.
Okay, thank you.
Sure.
We can always rely on you to come up with updated
The numbers.
information.
So may I go
Thank
back
you.
to my original
Yes.
question then? So Mr. Marchand, it sounds like you're saying that there have been officers that have gone out in the past. Ms. Ferry mentioned that they had collected evidence from several years ago.
They said they couldn't do it. They didn't have the right equipment.
But it sounds like we're saying they do have the right equipment. Are you able to just reconfirm that with Chief Heist that they have the appropriate gauge?
I'll check with them. Yeah.
Okay, thank you. Madam
And
Clerk, take.
just for the record, I think Colic Baby is pretty high on that list somewhere. If you look, Jamie.
Okay, he'll look that up and get it to you in 30 seconds. Thank you. Okay, let me see. Miss Senator Rogers, you have a question. Please come forward.
No, it was answered in the ensuing discussion that just happened.
Okay, thank you. All right, Mr. McGilvery.
All right, next slide. So in summary, the remedies residents can attempt a private action. But again, I think it's a difficult action from a proof standpoint, and the likely remedy that a court would issue would be an attempt to mitigate the nuisance, but very unlikely that a court would order a turbine dismantled completely. The other remedies, of course, are for residents, abutters, nearby residents to monitor noise, call the appropriate authorities. They should have, if they don't now, they should have the right equipment. And the town should review the information and data that's being produced by the monitors on the turbines now, and they should be reviewed by an independent engineer pursuant to the settlement agreement. So in short, the administrative finality blocks many of the legal avenues or arguments that one may have in terms of does it violate the comprehensive plan and things like that. And I think that there's virtually no remedy to remove the turbines completely. If I was honest and I was giving you a kind of a litigator's view of your likelihood of success if you were to bring litigation. So next slide. Again, another summary. Just several points from our review, and there's a couple issues with respect to notice that were brought up that we will dig into a little more deeply. Coventry, assuming that those check out, Coventry followed its ordinances for notification of butters, hearings, and permitting. There's no case law ordinance allowing the town to take the turbines down. Certainly not the ones that exist on private property. Private citizens may pursue a nuisance complaint against the owners. Private citizens should be vigilant in reporting noise issues, and those noise issues should be addressed with notices of violation and eventual fines. And private citizens may request a review of the monitoring used for the flicker to determine whether there is excessive flicker and whether it's accurate. So that's the end of the legal analysis. And I do have this a short to-do list of good points that people asked and needed clarification on. And I'll report back to the town council. And if they want me to appear again to answer those, that list of questions and dig down a little bit more on them.
Mr. McGilvery, you just mentioned you have a list. Could you just read off that list
Sure.
so that we make sure that we have covered everything that was mentioned?
Yes.
200 feet.
So yes, it's the height issue, how the ordinances would have affected at the time of permitting height, how they affect height of the turbines now, the notice provision raised with respect to, is it 200 feet from the property line? I think it is. And if so, was everybody who's within 200 feet of the property line given appropriate notice? Both those issues we'll confirm on. I'm going to put this on my list, although I'm not quite sure. I'm just personally interested in the Falmouth decision. I'm going to dig into that a little bit and read a little bit about that. And then the issue of retroactivity of ordinances, whether the limit is just whether you create an extreme hardship by retroactively applying a new ordinance. Is that the only time that you can't impose retroactive requirements on an existing use? I know already, no matter what, let's say the town passed a ordinance that said flickers now 20 hours per year, or noise is 40 decibels. I know at least one turbine owner who's going to run into court the next day and say that you're virtually shutting them down. But I'll look into that issue to confirm Brian Wagner's earlier opinion in any event. And then President Dixon raised the question of whether incorporating the industrial standards means that turbines are, by virtue of that, defined as an industrial use. So that's my to-do list.
Thank you. It's a little bit short. Do you want some more?
Sure. Yeah.
I think Mr. Marchand has a couple of issues too, doesn't he? You have a short list, Mr. Marchand?
Yes, I'm going to be checking with the police department on the calibration of their sound decibel meters and making sure they are adequate to the task. And I'm going to be doing the transition to take over getting the reports from Epsilon Association on the flicker, and I'm interested to research their methods of how that actually works.
And I believe that Mr. McGilvery also suggested that perhaps we might need an independent engineer to look at the monitoring units themselves.
So the way that the settlement agreement is written is that Epsilon Associates, which at the time was the town's independent engineer that was reviewing the information that was being provided by WED and Green Development, that they continue in that role, monitoring the data, because they were, at least at the time, independent. And that was, I can tell you, a big fight. WD and Green wanted to hire them and use them as well. And we said, no, there are guys, they're independent. So that's why we chose them. The settlement agreement allows them to be replaced by another independent engineering firm. So if they are no longer independent or cannot perform that function, they can be replaced by somebody else.
And I don't want to read into your careful wording, but do we have reason to believe that they are no longer an independent third party?
I have no reason to believe that they're no longer independent, except for my experience in 7 litigations with the plaintiffs and the applicant. But I have no reason to believe they're not independent. But that should be confirmed. And if they are no longer independent, another group should be chosen to monitor that data.
Okay. So can I just also ask, you just said that they're in 7 litigations, DePasquale? Or you have been involved in 7 litigations in which they have been
That's correct.
The plaintiff or defendant. So could there, I'm not a lawyer. I'm just wondering if, looking at their history, how they've done things not only in our town, but seemingly in other towns, is there any sort of retroactive lawsuit that could be brought against them saying, you're not acting like a reasonable party? Like you're not working with the town. You're not doing what you're supposed to be doing. It's quite obvious that as a business, you're a bad apple.
Well, the town did not have a good experience with them, but I think there are property owners who have had favorable experiences with them running turbines. So I can't speak to their reputation. All I can say is that if they are outside of the ordinances and not operating their turbines correctly and pursuant to the ordinances should be enforced, either noise or flicker.
Agreed. Thank you.
Thank you. Okay, are there any other questions from members of the public? There's a new gentleman up here.
If you want to go first, I'll you to talk.
Well, you haven't had an opportunity.
Well, thanks for having me.
Your name and address, please.
Josh Clements, 10 Gentry Farm Road. My question is, does this town have a comprehensive climate action or resiliency plan? I don't know if you can answer that question or if that's just a comment.
What do you mean by resiliency?
Right. So I see this issue of, siting of wind turbines, siting of solar panels as a result of not having a plan. Right. And so this town has been subject to not having a plan for how do we deal with historic buildings? How do we deal with the Johnson's Pond Dam? How do we deal with where wind turbines go? So if we had a comprehensive plan, we are ready and resilient, ready to adapt to climate change, which is real and is occurring, right? And affects every resident of this town. The drought where nobody had any water to water their lawns in Mr. LeBlanc's district, or high water prices, right? Not having enough water to fill the pond. All of these things are a result of climate change. When this summer we couldn't see into the sky because of wildfire smoke from California, climate change, right? Renewable energy is part of the future. I think the town is working towards it, whether it's on the landfill, the school committee buying, renewable energy from another gravel pit that's capped, but putting wind turbines in this location, obviously not ideal.
So I wanted to
I don't know how to address that holistically versus, these piecemeal things, right? We keep addressing the comments of individual constituencies within the town, whether it's the wind turbine today, Johnson Pond tomorrow, high water prices in, different districts, all of it's related. So how do we address all of it holistically?
Well, thank you. One thing we're doing is we have made a request for proposals to redo our comprehensive plan. So that is posted on the website, and we're waiting for some responses to come in, and that will be before the council as soon as we get some proposals. Mr. Marchand is keeping us abreast of that. So we all agree that the comprehensive plan is long overdue. There was an effort about 3 years ago to redo that plan. A consultant was hired. That person did not fulfill the responsibilities. One of the planners was assigned to work on that project, but did not really understand the full scope of what the consultant was supposed to do or not do. So we had a false start. I'll just say it was a false start. And it's taken us a while to get moving. I think you can see that the council is tackling some very, very critical issues. You're here at every meeting, or you're listening to us, so you know what we're doing. There are some gaps, and we're working on them. And I can understand the frustration that people in the community have with us, because everyone wants his or her problem solved immediately. And some people have been waiting, as the people who are here today, they've been waiting since like 2014 for something to happen, and that's a long time. So we understand people's frustration, and we're trying to tackle it. That's one of the reasons we're even having this meeting. So we got a legal opinion. Let's put it out to the public so they understand what we're hearing. You're hearing it for the first time, as we are.
No, absolutely. And I appreciate the council's addressing of both the acute and chronic issues within the town. So thank you. I don't know, Mr. Marchand, if you had something to add to that, or if that was covered.
It's covered.
I guess my other question is, right, so I live in the Western District, and I hear gunfire every single weekend. Gunshots register at 140 to 160 decibels. So I don't know if the police department would like me to call every time I hear gunshots, right? So it's another kind of fixed point of noise that causes a disturbance and also represents a safety risk to the public. I'll leave it at that. There's shot spotter technology that can be installed. It's installed in urban districts to identify gunfire and find out where that's coming from. So if there's noise complaints and we're supposed to call for 60 decibels, there's other challenges with noise and public safety in that respect.
In answer to that question, I have called the police to come because I have heard gunshots in my backyard.
Understood.
And there are ordinances regarding how close a gun can be fired to a property line.
I think my only other comment would be around just addressing how do we prepare for the future? So whether it's the next turbine, the next solar, farm that's coming in, how do we save either the open space or the rural character that exists within Coventry and make sure that we, keep all of the residents happy? And I recognize the challenge there. I do think it is very interesting to hear from some of our state representatives on how we could better improve or change zoning, knowing that some of the sediment, and I think this is a direct quote from one of the representatives, he who legislates least legislates best. But this whole challenge here is around a lack of legislation or a lack of understanding of the risk of not having legislation in place. So I would appreciate if the state reps who are here, and I appreciate them being here, could work towards installing, a state framework to allow for renewable energy infrastructure to be installed across the state. Thank you.
Thank you for your comments. Are there any other comments from members of the audience? Mr. Mays?
Madam President and members of the council, I commend you for
Your name and address, please.
Skip Mays, Perry Hill Road, Coventry. I commend you for having this session tonight. I think it's an eye opener for you as well as us. And there were some things that I had sort of a short list of things. And Madam President, you just addressed one of them, the comprehensive plan. I'm delighted to hear that that's back on the radar, because that would have prevented a lot of what we heard tonight had that already been done in a timely manner. Second thing is I would encourage the council to look at changing the noise ordinance, updating it, tweaking it. Many of the complaints that I hear, and I happen to live between two of the turbines, I'm blessed because I'm blocked with pine trees and hills that I don't live under it or in close proximity. So it doesn't become too much of an annoyance, but I hear it and I can my heart goes out to the members of the community who have to listen to it drone and drone and drone. The ordinance that currently exists fails to examine a number of the techniques and technologies that exist today that deal with sound. And Madam President, you and I had addressed this a couple of years ago, and we started down that path, but apparently it's gotten a little bit of a speed bump along the way, but I would hope that it gets addressed again. The other issue that's related to it is the issue that Madam President, you mentioned, infrasound. This is the big unknown. And I've testified before not this council, but previous councils, as well as the zoning. And that is infrasound is a psychological, neurological, physiological issue that there's very little known about in the public environment. I have an extensive military background and experience in that, but I'm not allowed to discuss it because most of it is at the classified level. However, there is information available in the domestic environment where you should be able to get good information. You mentioned, Madam President, that there is equipment out there that the town had looked at a couple of years ago to measure. I would encourage the town to keep that up and also include the use of or the measurement of infrasound in the forthcoming, hopefully, re-edition of the sound ordinance. The other and the last thing that I'll mention is that I would encourage the council to approach the representatives that are here tonight and encourage them to go forward to the Department of Health and encourage a study at the state level by the Department of Health to look into infrasound and the impact of infrasound. And it's not just in Coventry, and it comes from other sources, but wind turbines are a particularly notorious source of infrasound. I would encourage the state to go forward and look at and develop a plan, a policy, and hopefully some guidance for the communities such as Coventry as to how to deal with that going forward. again, I thank you for your efforts tonight, and hopefully we can get some progress going on this. Thank you.
Thank you, Mr. Mays. Representative Chippendale?
Yes, thank you very much. I have one question and then a comment, I suppose. The question is, since all of this has started, has the town implemented a sort of a cleanup fund for these renewable projects? Are you requiring contributions to a restricted receipt account?
Yes.
I see learned counsel shaking his head vigorously. Can you elaborate on?
Yes. I had a hand in at least drafting the new solar ordinance for the town, and that requires a bond be put up for a decommissioning.
Okay.
And the amount I think is established by the town planner or the town engineer to be sufficient to cover that process. I haven't looked at the more recent, I should say more recent than 2014, the newer turbine ordinance to see if it has a similar provision, but I can check that.
Yeah, I think I don't think there was initially, but that's why I asked the question first. I'm happy that the town did do that. So that being said, we are certain this whole thing. Nobody knew anything about it when it happened. It was like cell phone towers in the late 80s and the 90s. Like we didn't know, but everybody was freaking out about it. Same thing happened here. A lot of lessons were learned. If not for a brief, fleeting moment of clarity by Governor McKee when he vetoed a particular bill this year, there wouldn't be a tree left in green right now when he vetoed the interconnect bill, because that would have made this the Wild West. This is the cheapest land, is forested land. And that's where the developers, who are highly incentivized, regrettably, by my colleagues, with your taxpayers' money, to build these types of projects. Cheapest land, free money from the state and the feds equals more and more of what you have. Don't get caught with your pants down again like you did with the windmills, is all I can say. Think of everything that can and may happen, because it will. And there are developers out there who know this stuff inside and out and will go through every single hole and loophole they can find. Now's the time. And that's the only thing I can urge the council to do, so you don't find yourself with settlements and everything else again. Thank you for your indulgence.
Thank you for your advice, Representative Chippendale. Are there any other comments? Yes? Name and address, please.
Janice Stenson, 670 Nadia Oak Road. Excuse me. So when you were going through your list that you're going to go double check on, pretty much everything that I wrote down, except for one thing. You may have answered this already. You had said earlier in the beginning, and I apologize if I'm making you go over it again. You had said earlier in the beginning that regarding these special use permits, if the developer is consistently violating terms of an SUP, I think it was brought up before, can it be revoked? And you said you were going to get back to that later on, and you may have, and I didn't hear it, and I apologize if so. Is that a possibility?
Yeah, I believe that I will double check that. Okay. I did look at the ordinance, and it does suggest that it can be revoked, as well as fines imposed. That's my recollection of the ordinance. It states both. I think revocation is a very difficult road for the town if they tried it. But let me look into that a little bit further before I get too deep in an opinion that is not supported by the actual ordinance or the background facts.
Okay.
All right.
Great. So now
thank you so much. Senator Rogers.
While I am a resident Foster.
Your name and address, please.
Gordy Rogers, Senate District 21, which covers Coventry. A resident of Foster, former municipal leader for quite a few years before I moved up to the state level. And we talk about legislation. One of the main reasons why I went up to the State House was because of legislation that was damaging the municipalities. We talk about working with the legislation. There were several things that were brought up tonight that caused problems. One was the $5 kilowatt cap. That was done because certain people weren't making enough money and the legislature put a $5 cap. Prior to that, communities would be able to sit down and negotiate the tax treaty one-on-one, no interference. You didn't like it, you don't think you were getting enough money because you have to represent your constituents. Well, the legislature said, you know what? We're going to lean to the lobbyists supporting the green energy, and we're going to cap that. One size fits all. Doesn't matter where you are. So what I'm trying to get at is even this green energy, I work very close with the League of Cities and Towns because of my wheelhouse is municipal. So I'm on defense more than I'm on offense because there's a lot more bad stuff coming than good stuff that people don't even realize. You just had the pushing the green energy, and they just took a bill and they pushed it to an outside entity that's going to dictate your zoning. They're going to overrule your zoning on this basically by what they're doing. By taking the legislature out of this, it was voted on by them to meet certain goals by 2030 and 2050, net zero carbon. To do that, this stuff has to come. And it's going to work much like the affordable housing. When you don't meet your 10%, a contractor can come in and trample all over you because you don't meet your 10% and your zoning don't mean nothing. That's what's going to happen with this carbon zero by 2050. We're not going to meet our goals. And they're going to say, we need to do this to meet our goals. And it's taken right out of your hands and the legislature's hand on purpose. So there are many things that are coming this way, and I play defense, and a lot of it is bad. The forever green bills on the fire departments and stuff like that, it's difficult. So again, there's a lot of defense that needs to be played. And a lot of that means less legislation is better. The federal government has their power over what they should do. The states have their power, and towns should have their power over their districts and zoning and planning because Coventry is much different than Warwick. We saw the 20-day thing. That was done by the state. That hurt you. Maybe that should have been in your hands under your local town to say, you know what, we don't want a 20-day appeal process. We want a 30 or 40. So a lot of times it is legislature on the state that ties the hands of the community. So just wanted to put that up there.
Thank you very much, Senator Rogers. Are there any other members of the public who would like to ask a question? Members of the council?
Yes.
Ms. Ludwig.
So I do want to go back to, I believe it was Mr. Marshall's point, sitting in the back. Yes. So it's after 10 o'clock at night, and I know everyone's been patiently listening to everything here, but I am interested in what our public here has to say about possible uses of that settlement amount. I don't know if we have time to go into that tonight, but can we just at least ask? I know it's hypothetical, it's rhetorical, I should say.
It's not on the agenda.
Yeah, that's fine. So if we could maybe ask for you to reach out with your ideas to your council person to at least start a conversation with them, or send it to all of us, I think that would be a good starting point just for us to get an idea of what we could possibly do with that money.
Thank you, Ms. Ludwig. Feedback from residents is always extremely valuable, but we just have to bear in mind that Mr. McGilvery said that it needs to be in consideration of the good of the whole public, the whole community. So we just need to bear that in mind when you think about your suggestions. Any other questions from members of the council? Is there anyone? We have to open up public comment officially. So public comment is now officially open. We've had lots of comment during the meeting, but we need to open public comment officially. Is there anyone on chat? No. Okay. May I have a motion? Well, first of all, I'd like to thank you all for coming this evening. We appreciate the questions. We've come away with many action items, which many of us have. You have an action item to send us some feedback also. As I said before, when we started, we wanted to lay on the table what we have been able to find out through legal discourse. And I hope that you found this valuable. I know that many of you have done your own research for many, many years, and maybe you didn't hear anything new. But I think for many residents here and also members of the council, it was very informative. And we do have some action items that we will work on as quickly as possible. So we perhaps can have a follow-up session as soon as possible, as soon as we have something to report out to you. So if I hear no other public comment, then I would like to entertain a motion to adjourn.
So moved.
Thank you. May I have a second?
I'll second it.
Thank you. Any discussion? Roll call. Vote, Ms. Ludwig?
Yes.
Mrs. Shockley?
Yes.
Mrs. Lima?
Yes.
Mr. LeBlanc?
Yes.
Mrs. Dixon? 5 yeas, no nays. The motion passes. We are adjourned at 10, I think about 10:10.